Hello and welcome to Vision Insights. Today, as you all know, that we have already started the lecture series on company law, and I'm specifically covering the syllabus of University of Calcutta. So, in the lecture series, we have till now done more. We have learnt about directors, their role, their duties, their vacation of the office of the director, resignation of director, liabilities of directors, rights of directors, appointment, qualifications, everything we have done. So now in the lecture series, the new topic for today is managing director. Before starting the topic, let me introduce myself. Myself, C.S. Trupti Upadhyay, have started a lecture series on company law, and obviously this is useful for the students of University of Calcutta semester 2. Specifically, we are focusing on the company law paper, and obviously apart from that, other students from other universities can also view these lectures, where if you have a subject of company law, obviously this will be useful to you as well. And other people, other aspirants like net aspirants and other aspirants of different competitive exams can also view the lectures, wherein you have to study and you have to understand the company law. Obviously this is useful to you as well. So be it a academic purpose or for a professional purpose like CA, CS, CMA, cost accounting, or be it a competitive exam, these lectures will be useful to all kinds of audience. Let's start today then. And I am a qualified company secretary and also net qualified in commerce subject, and also holding a Master of Commerce degree from the University of Calcutta itself. Now let's begin. Before starting, these are few reference books, and these are for Calcutta University, but you can also have other kind of books material which you feel it's better and you can understand, you can use it. This is not the, I would say, the exhaustive list. You can add whichever book or whichever material, be it online, offline, whichever material you get which is useful to you. And I would also say that the lecture material which I am providing you is also very much authentic, because I've taken it from the authentic sources like Ministry of Corporate Affairs website, and other authentic and updated material you will get from me as well. So you can refer my material is sufficient. But then also, if you want to go through in detail or more analysis, for more practice, you can use the MCQ book provided by S.K. Pandap, that is a writer and this is the book from Law Point, right? And these are the Oxford University book is also there. D.L. Datta is also there from TD publication. Bhadra Satpathy has also good explanation, right? And also you can view my lectures more than once or twice, so you will get more concept clarity, and we are going one by one, concept by concept, section by section in detail. So you have missed any of my previous videos, you can go to my channel, visit my channel, that is Vision Insights, and therein you have to go to the company law playlist. You will get all the previous lectures you have missed. So I would request everyone that after viewing this lecture, you can always go back and check out in my playlist of company law. You will get all the useful material there, right? And this is our website of Ministry of Corporate Affairs, MCA website. This is the hyperlink which I have shared with you, and for using this, this is the link, I would say URL. So with the help of this URL, obviously you will be able to access this website. And why this is important? Because this website will give you the updated act and the rules, right? So it is real-time basis, the updates happen in this website, so it's more updated than your books as well. Okay, so I generally refer these e-books and all. And obviously the material from MCA is more authentic. There is no question about it, people. So this is for your knowledge, that you can access this e-book of Companies Act 2013. It is an online version made in collaboration with Institute of Company Secretaries of India. So ICSI and MCA has done it, jointly collaborated in this project, and they have done this, and this is a great achievement, I would say, right? So this is from the government website, most authentic. You can access this online ebook, fine, and this is the way you can do it. Now let's begin our lecture. Our lecture This way the book looks like ebook, and here you can search the content by section wise. So you type the section number and the search panel, and you click on the search button, you will get it, whichever section notes you want. And obviously rules are also there, effective dates are there, notifications, circulars are there. So obviously you will get an updated, real-time updated Companies Act with all the amendments. Okay, and with effect from which date these amendments will be effective, that also you can check out. And also the previous text is also available. So this is really good. And in the website of MCA, one more information I want to give you, that you also can get a PDF version of the Companies Act 2013. So those who want to read it offline, that is for you. Download the PDF and do it. Otherwise, I would request everyone to see this only. That is our ebook on MC, ebook from MCA's website, right? Most authentic, most updated, real-time basis updation happens. Okay. Our lecture for day is Managing Director. This Managing Director topic is a little vast, so we'll cover a series of lecture on MD, and this is our part 1 of MD's lecture. Fine. Now, before starting Managing Director's role, responsibility, who is it, so we should understand that who is Managing Director. So let's first define Managing Director. Definition of Managing Director is given under section 2 subsection 54. People understand, be it a competitive exam or an academic exam, section numbers are favorite of our examiners, right? So this is an important section, 2 by 54. So 2 by 54 defines what? Defines our Managing Director. Now what is written under 2 by 54? Managing Director means a director who, by virtue of the articles of the company or an agreement with the company or a resolution passed in the general meeting or by its board of directors, is entrusted with the substantial powers of management of the affairs of the company, and includes a director occupying the position of Managing Director by whatever name called. So few important keywords which are highlighted and also underlined. Let's understand one by one the meaning of it. This is written that the articles of the company should have the provision regarding the appointment of MD. Right? First requirement. Or MD may be appointed through an agreement. So agreement will happen between a Managing Director, between a person and the company. Right? Next is that or Managing Director can be appointed through a resolution in general meeting or by the board of directors. So maybe by shareholders may appoint him, or the board of directors can also appoint him in the board meeting. So through a resolution, so you can also use if it is a GM, you can use an ordinary resolution. If it is a BM, that is board meeting, you will use a board resolution. So these are the ways in which the Managing Director can be appointed, right? And now what is the role of Managing Director, or what are the responsibilities? In brief, we can say that he has the substantial powers of management of the affairs of the company. We'll understand what is the meaning of the substantial powers. It is given in the explanation. And next thing is written that it includes, means a Managing Director is a director, any director who is occupying the position of such director is called the Managing Director. So if any whole-time director is there who is behaving like, or his duties are like such that he is holding some substantial powers, he may be termed as a Managing Director. Though specifically he is not being defined, he is not being given that post in the company, but if he is the person who is holding the substantial powers of management, then obviously you can consider him as the MD of the company. Fine. So that is only written by whatever name called he may be there. A director occupying the position of MD will be considered as MD. Now let's understand this word, that these are words of most important. People, please be very careful with this. Substantial powers of management. What does this mean? Because the debate happens in the court here only. So let's understand, for the purpose of this clause, power to do administrative acts of routine nature, when so authorized by the board, such as the power to affix the common seal. So what is written, that board will authorize the Managing Director with some administrative powers of routine nature. So recurring nature, routine nature work, admin work will be handled by MD. But how MD will get to handle this work? Only by the authorization of board. So board has to authorize him to do this work. Fine. So here it is written, few administrative work is the power to affix the common seal. We know that the signature of the company is the common seal. So in any document, if you want to affix common seal, but the MD should have the authorization from the board, and then the MD will be acting upon it. Or draw or endorse any check on account of the company. So company's bank account, so to access the company's bank account, to draw any check or to endorse any check in the bank account, or to draw or endorse any negotiable instrument, MD will be authorized by the board, and these are administrative work. MD can do it. Next is that the certificate of, I would say, share certificate. So share certificate signature is there, right? So signature of whom is it there? MD's signature is there. How MD can sign it? Only by the authorization of the board. So if he is authorized, he will be signing on the share certificate also. To direct the registration of any transfer of shares. So obviously we know that if shareholder want, they can transfer the shares, right? So if Mr. A has transferred the shares to Mr. B, obviously within 30 days of transfer through Form SH4. Form SH4 is there, the transfer date. Form SH4 is there, so SH4 need to be given to the company or a company's official, most preferably the company secretary of the company, and there will be a request of registration of the transfer. So here the transferor's name will be deleted and the transferee's name will be added to the register of members, which is being prepared or maintained by the company in Form MBP 1. Fine. So this also direction will be given, right? Company secretary works through board. So all the instructions given by the board or the managing director. So managing director will instruct the company secretary to register the transfer of shares, right? So these are all the administrative power or the substantial power of the management. But these are not the exhaustive list, I would say. You can still add many things. So shall not be deemed to be or included with the substantial powers of management. So whatever things we have discussed above, these shall not be deemed to be included within the substantial powers of the management. Now your question would be there. Sorry. Now your question would be there that what is the substantial powers of the management? Basically, substantial powers of management means that these are all administrative powers. Administrative powers of routine nature are excluded from the definition of the substantial powers of the management. That is clear. So this means that substantial powers of management means any other kind of decision which is more important for the company has to be taken in consultation with the board and in the leadership of the managing director, then and of course the chairman of the company. These are all the substantial powers of management. Fine. So these are all routine nature work which we have discussed in the explanation. These are not considered as the substantial powers of the management. Fine. So if we know what is not included, we can include those things which will be included then. Fine. Now let's move to next. We are discussing today one section, that is section number 196. Section 196 speaks about the appointment of MD. Whole-time director or manager. No company means any company, if the company wants to appoint an MD, then obviously the manager will not be appointed by the company. So MD and manager are the two parallel posts. Okay. So if a company has a MD, company shall not appoint a manager. If a company has a manager, company shall not appoint a MD, because both the powers of both the manager and the MD are as such same, right? So that's why both the parties, MD and manager, should not be there at the same time in any company. Now the term of the office of managing director, whole-time director or manager, how many years they can be serving our company? Not exceeding 5 years, means maximum 5 years term they can serve at a time, right? And I would like to just do a little brainstorming. Just tell me that does MD retire by rotation? we have learned in section 152 subsection 6 that directors retire at every AGM through rotation. Right? So there is some principle is also there, 2/3, 1/3, which we had discussed in our previous videos. So just tell me in comment section below that do MD is such a person that he will be retiring by rotation? Yes or no? I'll tell you at the end of this lecture. Right? So if you want to try it out and give me your response in the comment section below. Then I will also tell you at the end of this video, you will get the correct answer. Okay. Now let's understand MD more. So there is reappointment is possible. Yes, reappointment is possible, but not earlier than 1 year before the expiry of the term. What does it mean? Suppose MD was going to retire in 2021. Okay, we have appointed one MD in our company, and in 2021 January, he will be retiring 2021, right? So he can be reappointed, and reappointment decision can be taken 1 year before the expiry of his term. So obviously in 2020, the directors can decide, board of directors can decide whether they wants to reappoint him, or shareholders can decide whether they want this MD to continue for another term of 5 years or not. They will decide, and they may reappoint him. So in only 2020 they can decide 1 year before the expiry of his term. In 2019 they cannot do so. Fine. Now we are moving into this, the age limit. Minimum age should be 21 years and maximum age should be 75 years. So a person between this age 21 years to 75 years is eligible to be appointed as an MD, WTD, managing director, whole-time director, or a manager. Fine. If a person more than 75 years want to be the managing director, wants to get appointed as a managing director, then what we have to do? The company has to pass a special resolution, right, in the general meeting with an explanatory statement which will be annexed to the notice of such general meeting, that the directors want to appoint a person who is more than 75 years of age, and with a justification that why they want to appoint him, what's the special thing in that person, and why the company requires him, that we are appointing such a person who is more than 75 years of age, and he is obviously an elderly person. Why the company wants to do it? So justification need to be given in the explanatory statement itself. In the notice it will go to the shareholders. Beforehand the meeting will actually occur and they will actually pass the SR. Fine. Other thing is that another route is there. If the company do not want to pass SR, then how they can do it? Then it will happen like that votes cast in favor of the motion, means in the general meeting there is no SR, because you know that for SR we require 75% of the votes in favor. Then only the SR will happen. 3/4 majority actually in the general meeting by the shareholders, right? So 3/4 people or the 75% of the total should agree to pass SR. But if there is no SR is not possible, then another thing is possible, that votes casted in favor should exceed the votes casted in against, right? And apart from that, here if there is no SR, then we require to have the appointment done with the central government approval. So an application will be made by the board that such appointment is really most beneficial to the company to central government. And if central government is satisfied, board will make an application, and CG has to give the approval. If CG will be satisfied, then only CG will give the approval, right? So after the approval of CG comes, then only that person who has attained the age of 75 years can be appointed by the board or the company. Fine. Now we are learning about the disqualification of MD, WTD or manager. We have already understood in section 164 that Its specifically dedicated section is there. Section 164 subsection 1 and section 164 subsection 2 speaks about the disqualification of directors in general, right? But these disqualification which are laid down under 196 subsection 3 are specifically focusing on the MD, WTD or manager. So you have to understand that MD is also a director, right? A whole-time director is also a director in the board. So these two subsections will attract for disqualification of MD. Which two sections? Please kindly remember, it is very important for your exams. 164 section is important, and also section numbers 196 subsection 3 is also important. Okay? So let's understand under subsection 3 what are the provisions. Three conditions are there. Disqualification condition, that company shall not appoint a person who is undischarged insolvent. So insolvency case is going on, or at any time he was been adjudicated as an insolvent. So he was declared insolvent by any court at any time before, or his case is going on in the court of insolvency, that he will be discharged soon by the court. So insolvent person cannot become the MD. Next is that he has at any time, word any time is very very important, understand, at any time he suspended the payment of the creditors. So he have not made the payment to the creditors, or at any time he had done some composition or compromise with the creditors. What is the compromise we can do? Suppose 100 rupees we had to pay to a creditor, you make a compromise and bargain with him, and then it is being understood, or it came to an understanding that you will just pay 85 rupees to him. So this is called compromise or composition. Next we are moving into the next thing. At any time he was being convicted by the court. Understand, word convicted is written, not accused. Director can be accused with several offences, but conviction means that he was fully guilty. When he was convicted by the court is the next thing. So here it is written convicted. So he should be convicted by a court of any offence, and not only convicted, he should also be sentenced. Sentence means he should really go to jail. Sentence for a period of more than 6 months, right? So more than 6 months sentence has been passed against him, and he has to serve that sentence also. So convicted by a court of any offence and sentenced for a period of more than 6 months. So greater than 6 months imprisonment was sentenced. He was sentenced for that imprisonment by the court, right? After being proven guilty. Next, these are the three conditions. Any of the three conditions, if it occurs, then MD, manager or whole-time director, they cannot be appointed. That person cannot be appointed in these posts. Now we are moving into section 197. 197 in next lecture we will deal with 197 in detail. So I am not going into detail. So schedule 5 is also being we will be doing in detail. So subject to these two section 197 and schedule 5, MD, manager, WTD shall be appointed, and the terms and condition of such appointment including the remuneration shall be approved by the board of directors at the meeting. So who all are appointing them? They are appointed by the board of directors in the board meeting. MD, WTD or manager are appointed by the board in the board meeting, subject to the approval of the shareholders in the next general meeting. So obviously shareholders approval is required, but afterwards you can take it after the board has appointed them in the board meeting. In the subsequent next general meeting, the approval of the shareholders shall be taken, and also if the appointment is it in the variance of the conditions specified in the part 1 of the schedule 5, then obviously the central government approval is also required. So what is this? How the central government approval is taken and under which conditions it will be taken, we will be doing it in details in the videos of schedule 5. Okay, so wait for schedule 5 videos. Next, notice convening the board meeting or a general meeting in which these parties will be appointed, either MD, WTD, manager, shall be containing the conditions, terms and conditions of their appointment, remuneration payable to them, other matters included such as the interest of the director or the directors, whether the present directors of the company are interested in the appointment of the MD, like suppose the one of the father is already a director, and the father and in the board meeting the son is going to be appointed as the managing director of the company, right? So obviously father has to state his interest, that whether he is interested or not. Father means the existing director has to state the interest, whether including the interest of the director or the directors in such appointments. That means this. Next, one more important form is there, Form MR1. Please understand, special resolution, if MD is appointed through special resolution, we will be filing Form MGT 14 within 30 days of his appointment, right? Apart from that, we will be also filing Form DIR 12 for the appointment of MD, right? Within 30 days of his appointment. These are the forms which will be going to the MCA's website through MCA portal, right? So it is we are filing to the registrar of the companies these form. And apart from this two forms, this form is also required, that is Form MR1. MR1 shall be filed within 60 days. Please people remember the number of days. It is very important along with the form numbers. DIR 12 30 days. MGT 14 if SR is passed then 30 days. MR1 60 days from the date of such appointment with the registrar. Two companies are exempted, that is the private companies, and government companies do not have to file this form MR1. Okay. Where an appointment of an MD or WTD is not approved by the company in general meeting. Suppose board of directors have appointed this MD, fine, but now he also have started his job. He has resumed his. He has taken the power. He has taken his office. He is doing all the acts, but his appointment is not subsequently ratified or has been not approved by the shareholders in the general meeting. No meeting happened, or meeting happened also, this matter was skipped. Now what will happen? Any act done by him before such approval, means his appointment's approval is not being given by the shareholders, then any act done before him. So he had already joined the office and he was working for the company. So all the acts shall not become invalid. So it will be deemed to be valid, right? Here also private companies and government companies are exempted from this requirement. Fine. Thank you all. Hope you like this lecture. And if you like this lecture, please stay tuned to our channel Vision Insights for more updates and more knowledge sharing or with respect to company law, right? And obviously, I think so this will be beneficial to you in your upcoming exams. And if it is beneficial to you in this upcoming exams, please share the video, like the video, give your comments, suggestions, and of course subscribe the channel. Please support the initiative. Thank you all.